Thank you, Mr Speaker. I welcome the opportunity to stand and speak to this member's bill in the name of Green Party MP Catherine Delahunty, and thank her for bringing this issue to the Parliament and indeed our Select Committee. We do have some bad news for her though. Although she tirelessly put this to us, the Select Committee did a tremendous amount of work on it, hearing 27 submissions, holding hearings in Whakatane and Wellington. As a committee, we came to the majority belief that, in fact, this legislation was not necessary. So we won't be supporting it in the second reading here this evening. Mr Speaker, National doesn't support this bill. We understand that the purpose of the bill is to limit the time period for which a discharge permit or a coastal permit may be issued to 5 years, when a permit to discharge is deemed necessary due to exceptional circumstances. And those circumstances are exceptional. In all the cases we did investigate, the Environment Court confirmed this, and we see no reason to change the law. People are understanding pretty clearly in New Zealand that National does know how important the environment is to New Zealanders and is to our quality of life. It's central to our international reputation, our primary sector, our growing tourism market and, of course, our economy. We're delivering on our promise to make the RMA a law that better balances environmental protection and economic growth. It's not a tool, the Resource Management Act, for extreme environmental activists to stop growth, to rid the country of jobs, to involve themselves in economic destruction. It's an important law. The key factor behind our ongoing RMA reform is the drive to ensure enduring outcomes while reducing the time, costs and uncertainty involved in the process. And that's, of course, what we're doing. So we came to this bill as a committee, and we received and considered 148 submissions from interested groups and individuals, as well as 3 form submissions comprising 18 individuals. The committee heard 27 submissions, as I said, in both Whakatane and Wellington. We've examined the Resource Management Restricted Duration of Certain Discharge and Coastal Permits Amendment Bill, and we recommend that it's not passed, and that's where I'll be casting my vote this evening. In regard to the water quality issues, which was the high-level issue that we examined, we weren't persuaded as a committee that this bill is the most effective way of, in fact, improving water quality. Rather, initiatives at a national level, such as the Land and Water Forum and the National Policy Statement for Freshwater Management, are more likely to be effective in driving regions and districts and local communities and catchments and individuals into making good decisions about what they do in their environment, which eventually leads to effects on water quality. On the exceptional circumstances issue that was raised at committee and by the member Catherine Delahunty, it was questionable whether exceptional circumstances was a good reason to allow discharge permits. Section 1072A of the Resource Management Act has only been used a few times, and in each case in the Environment Court has actually applied a stringent test and considered timeframes. Each case has also involved detailed discussions about what constitutes exceptional circumstances, including these considerations: something out of the ordinary or unusual or not typical, a substantial investment, projects that involved a regionally or nationally significant resource, projects that out of their nature rely on the use of the waterway, and projects that will contribute to resilience on national hazards. And that's a very broad, gives very broad scope of consideration indeed. To narrow things down to simply direct environmental consequences is not wise, particularly when many of these discharge permits are brief and due to unforeseen circumstances. The committee believed that a shorter duration for exceptional circumstances could not adversely affect the ability of companies to raise capital and ensure adequate long-term investment. So it could adversely affect their ability to do so. So, in summary, Mr. Speaker, the government's resource management reforms are about ensuring we manage our resources more effectively and efficiently to deliver both economic and environmental benefits for future generations. It's a balance. That's why we're a centre-right party. We look at both sides of the argument. We're looking for a way through, for solutions, a balanced approach. We're not sort of part of an extreme movement on one side driving only one agenda. We're the type of party that you would like to run your country or your business or your family. We're not sort of mad out on one side. And the government is currently in the second phase of our RMA reform and addressing whether this particular section needs to be amended should be in part of full or well-thought RMA reform packages. Now, Section 107(2)A, as I discussed before, which this bill seeks to amend, is really applied in discharge or coastal permits. There's no evidence that this section is being used inappropriately or in a widespread manner. I mean, case law, examples of where it has been brought before councils and the courts are very few, and it was so easy for our committee to dissect them. They were so few in number. Where Section 107(2)A has been applied, there have only been limited instances where permits issued under the section have resulted in appeals to the Environment Court. So in each case, the Environment Court has applied a rigorous test to validate the exceptional circumstances definition and reaffirmed conditions of the permits issued to minimise environmental effects. In other words, when the permits issued were tested on appeal to the courts by litigants concerned about what was going on, sensible people sitting in the judicial hierarchy looked at all the information and arguments and the science and took it upon themselves to make a decision which essentially said that all was essentially well. So in addition, limiting the time frame for consents issued where Section 107(2)A applies as proposal would have no effect on current consents. So there's no way to use the legislation on looking back retrospectively to consents that are already granted, which the member claims there are problems with. This is not the tool for Catherine Delahunty to fix problems which she perceives to be in existence at the moment under current permits, because it can't do that. It can't do it retrospectively. In addition, it's not likely to affect many consents in the future given the current limited use of the section. And that's, as I expressed, is that historically this permit under this consent condition, or these consents under these permit conditions, are not often sought and not often given. So National's reform program has been about simplifying and streamlining the RMA processes, providing stronger central government direction and addressing problems in areas such as infrastructure, water and aquaculture and agriculture. Now, we're not in the business of making the resource management law more complicated and more difficult for both environmentalists, businesses and Joe Kiwi to understand. We want the process to be simple and accessible, not more complex. And I'm afraid introducing legislation like this to the House That makes things more complicated and difficult for people, is not what this Parliament supports, certainly not what voters support when they put this government, this Parliament together, forming a national-led government with a particular view. So, Mr Speaker, I do say that we will be voting against this in the second reading. I can't commend the bill to the House, although I acknowledge Catherine Delahunty's work.
Moana Maki.
Thank you, Mr Speaker. Contrary to what the previous